In Texas, what do you do if you get injured on the job, and how do you protect yourself so that you can get back to work and back to providing for yourself and your family?
These are questions that injured workers often don't really know the answers to because their employers just don't provide enough information about the insurance coverage available for work injuries or about the process of actually opening a claim. So, Texas injured workers are basically left to figure out on their own whether an employer even has any work injury benefits. And if they do, how to actually access those benefits when an injury happens. To do that, the first order of business, really, is to learn the rules of the claim. Generally, there are 4 possible scenarios when it comes to work injury insurance. First, your employer could have Texas workers' compensation. And there are ways to confirm if that coverage is truly workers' comp under Texas law. The key thing to understand is that not all Texas employers are workers' compensation subscribers. Second, the employer might not have Texas workers' compensation, but instead have a private work injury insurance plan. This is private coverage, and these employers are known as Texas non-subscribers. The law that applies here is very different, and understanding that difference is crucial for getting a positive result in your case. Third, the employer could be self-insured. These cases are similar to non-subscriber claims, and the laws that apply are very similar as well. Again, these are not Texas workers' compensation claims. And fourth, the employer might have no insurance at all. Unfortunately, there are situations where an employer has chosen not to carry any work injury insurance. And in those cases, the options for injured Texas workers are pretty limited.
How do you know if you need a Texas non-subscriber work injury lawyer?
Getting familiar with the rules of the claim is not always easy to do on your own. When you suffer an injury on the job, it creates a big disruption in your daily life, and it puts your family's financial well-being at risk. And, that's where a work injury lawyer can really help. They can handle all communications with your employer and the insurance company, so you can actually focus on your recovery. At the end of your medical treatment, your work injury lawyer will be fully prepared to do whatever's necessary to resolve your claim, including filing a lawsuit if that's what it takes. It's important, really important, to have your case reviewed early so you can understand what legal rights you have and what steps you should take next to protect yourself and your family's well-being.
How are my legal rights different from when an employer has Texas workers' comp coverage?
Your legal rights are very different when your employer is a non-subscriber, meaning they don't have workers' compensation. And, one of the first questions you should ask is whether your employer actually has workers' compensation insurance. Sometimes your employer, the insurance company, and even the insurance doctors, they'll use terminology, forms, and documents that look exactly like the ones used in real Texas workers' compensation claims. But yeah, this does not mean they have Texas workers' compensation coverage. Your employer might be self-insured, or they might be a Texas non-subscriber. There are resources out there to help you figure out whether your employer has workers' comp, so you don't have to guess.
What is a Texas non-subscriber employer?
A Texas non-subscriber employer is basically a company that has chosen to go outside of the Texas workers' compensation program. And they've purchased a private insurance policy, one that's supposed to provide coverage and benefits to employees, including the specific benefits that apply to, on-the-job work injuries. So by deciding to step outside the Texas workers' compensation program, the non-subscriber employer still has insurance to cover injuries to its workers. But the rights that an injured worker has after coverage is denied are very, very different from the rights under a traditional Texas workers' compensation claim. It's really important to understand this. There has to be a big incentive for a Texas employer to intentionally open themselves up to being sued, because the economics of the non-subscriber program honestly favors employers, and it puts them right in the driver's seat when it comes to approving the medical care that injured employees actually receive.
Can you file a lawsuit against your employer if their negligence caused your injury?
There are major differences between Texas workers' compensation and non-subscriber claims. After a non-subscriber claim has been rejected or denied, the most important right you have, and one you don't have under workers' comp, is that you can file a lawsuit against your employer for failing to provide a safe workplace. Because Texas non-subscriber employers have purposely decided to go outside of the Texas workers' compensation program, they lose the protection against lawsuits from injured employees, and they lose the right to argue that you, the injured worker, were partially at fault for your injuries. That's something that's usually allowed in other personal injury cases in Texas, but not here.
Are there a lot of non-subscriber employers in Texas?
You may be surprised, but yes, there are several very well-known companies that have elected Texas non-subscriber status. The most common non-subscriber employers are large retail and restaurant chains that operate all across Texas. Some examples of companies that are non-subscribers and don't have workers' compensation are Walmart, Amazon, H-E-B, Target, Lowe's, Home Depot, Office Depot, Costco, and many others. You really have to do your research or talk to someone who can help you verify whether your employer has workers' compensation or if they're a Texas non-subscriber.
What do you have to prove to be successful in your non-subscriber case?
To have a case against your employer, you first need to determine whether your employer was negligent. Generally, negligence can be established if you can show that your employer failed to provide a safe workplace. If they didn't provide that safe environment, well, that could mean they breached a duty owed to their employees. And if your injuries can be clearly connected to the incident, then you might actually have a pretty solid case against your employer.
Can your non-subscriber employer blame you for your injuries?
A non-subscriber employer cannot argue that you are partially at fault for your injury. It is not a valid defense for a non-subscriber employer to say the injured worker was contributory negligent, or that the employee assumed the risk of injury or death, or that the injury was caused by a coworker. What a negligent employer will try to argue is that the injured employee was 100% responsible for the injury.
Why are a large number of non-subscriber cases subject to arbitration instead of being able to be filed in state or federal court?
Texas non-subscriber employers typically require new employees to sign an arbitration agreement, one that says any dispute that comes out of your employment has to go to binding arbitration instead of state or federal court. And, well, requiring that your work injury case go to arbitration gives the non-subscriber employer a bit of control over who actually hears and decides the case. So instead of a judge or a jury, you get an individual arbitrator, someone selected from a list of maybe 6 to 10 candidates. And whoever ends up being chosen, that arbitrator becomes your judge and your jury. Usually the list includes former judges or attorneys with several years of experience. Now, while arbitration is sometimes seen as not exactly ideal for an injured worker, it can actually help move your case faster because the whole process tends to follow a much tighter schedule.
Do all non-subscriber employers have arbitration agreements?
While it's rare, there are situations where a non-subscriber employer just never asks their employees to sign an arbitration agreement. And in those cases, you still have the right to file your lawsuit in state or federal court, depending on who the defendant is.
What damages can you claim in a non-subscriber case?
You have to understand, every non-subscriber case is different, with its own set of facts. And honestly, what damages you can claim will depend a lot on how serious the injury is, and whether the worker can get back to their pre-injury health. Generally, in a non-subscriber case, an injured worker is entitled to claim the usual personal injury damages, which include medical expenses, past and future, lost income, and earning capacity, also past and future, physical pain and mental anguish, past and future, physical impairment, and disfigurement.
Can you file a non-subscriber lawsuit if an injured worker passes away?
The most serious non-subscriber cases are the ones where the injured worker actually passes away. And when that happens, certain family members may be able to file a wrongful death lawsuit against the employer. Just like other non-subscriber cases, a wrongful death claim can be made when a worker is killed because of the negligence of their non-subscriber employer. Now, there are specific conditions that have to be met to qualify as someone who can bring a wrongful death non-subscriber case.
Why do you need to consult a work injury lawyer?
At Sandoval Law Firm PLLC, we operate with 3 very important goals in mind. First, we provide sound legal advice backed with aggressive representation. Second, we make sure our clients get personal service, the kind you just don't see at most law firms. And third, we treat every single case like $1 million case. When you call the Sandoval Law Firm, you're actually speaking directly with me about your non-subscriber work injury case. And I do everything I can to earn your trust early. and to keep you informed throughout the entire process. We take cases all over the state of Texas, including Houston, Dallas, Austin, Corpus Christi, San Antonio, and the Rio Grande Valley. Call us now and get the representation you deserve. Putting up the fight for injured Texans' rights is what we do.